Quickie. Pretty much since movies began, states set out to censor them. Maryland was one such state, and it took until 1965 for its censorship to be overturned on First Amendment grounds. Maryland statute required all films to be submitted to a state board for approval before they could be publicly shown. They could censor and deny films just on their opinion that it was obscene, sacrilegious, indecent, inhuman, immoral, or likely to incite criminal activity. Ronald Freedman was a movie theater owner who sued on the basis that this violated his First Amendment right to freedom of speech. He argued that the law had no clear standards or guidelines, resulting in arbitrary decisions by the board. It also had a chilling effect, making theaters reluctant to show more controversial films. In addition, he argued that, since there was no requirement for a prompt judicial determination, it could be months before a film was ultimately approved. The Supreme Court unanimously struck down the law on the basis that it was a reversal of burden of proof, since theaters had to prove a film was permissible. They also acknowledged that a censorship law was a form of prior restraint. They also said that it made the censorship board act as though it had judicial powers, even though it was under the executive branch. While they didn't rule censorship laws completely unconstitutional, the Freedman decision established 3 safeguards. One is that the censors had the burden of proof. Another is that they had to either promptly issue a license or go to court to demonstrate why a film wasn't protected under the First Amendment. And the third was that any censorship statute had to provide for prompt judicial review. As a result, states found it difficult to maintain censorship statutes and ended up getting rid of them by 1981. And these standards are in place for any statute of prior restraint, not just for films and not just for obscenity.